Great. Welcome. It's lovely to have you all here today. This is the third installation of the seminar series on the histories of capitalism and race. In a sense, it's the third installation because this is our third time running a series like this. It's also our third speaker this year, so it works out. So before we get started, I just wanted to say a few thank yous. I wanted to thank my co-conveners of the series, Hingame Ziai, Lisa Tilley, and Samia, who will be coming in any minute now. Samia Khatoon. It's an absolute, oh, there she is. Just to say it's an absolute kind of pleasure, but also privilege to be working with the three of them on this series. So thank you all. And Tanvi Kanchan, who is an incredible support to us. None of this would work without her. All of us, including Omar, would attest to that. Yeah, so this is part of a seminar series, and this year our theme is Empire, Race, Capital, Readings Beyond the Atlantic. And we hope the idea is to be creating a conversation across the books that we have today, we have this year. And so we are hoping that people are coming, and I can see faces from different seminars. So it's nice to see people coming through the year and kind of seeing where the conversation goes. Speaking of conversation, I wanted to give you a sense of how we're setting it up today. So we'll start out with 20 minutes from our speaker, who will give us a little bit a sense of the book, although I'm sure you've all read the chapters that we circulated. And then we will have respondent comments from Hani Ziai and Yusra Hussein, who are both experts on these questions. I will tell you more soon. And then we will give Omar a chance to respond to these comments. Then we're actually going to hold off the panel for a bit, opening it up to all of you. And the way we envision the conversation is not so much as a Q&A directly at Omar, although that will definitely be part of it. But we are also interested in having an intellectual conversation develop in the room. And so that's why we're going to hold off, ask Omar to wait for a bit and collect both kind of questions, comments, ideas. People can go off of each other, kind of create that environment. And then we'll give Omar a chance to respond to some of it, not all of it. And then we'll do another round of that. And that will probably bring us to the end of our 2 hours. So without further ado, I wanted to say that we're incredibly excited to have Omar Cheta here today. Not only is he presenting his book, but this is actually the launch of his book in the UK, which is just hot off the presses, I don't know, 3-4 weeks?
September 30th is the official publication date.
So they didn't even make it to the month. So we're very, very lucky to have Omar here. I personally feel, that this is a very special talk. Omar and I have been reading each other's work, commenting on it for, I think, over a decade now, which doesn't age, not talking about age at all. So it's beyond kind of, it's kind of surreal and very exciting to be holding this book and have Omar here. So to give you a sense of who Omar is, Omar Cheta is a historian of the modern Middle East and assistant professor at Syracuse University in the history department. His primary research interests are the histories of law and capitalism in 19th century Egypt. And his book, which you all are seeing today, How Commerce Became Legal, Merchants and Market Governance in 19th Century Egypt, was published by Stanford University Press. So Omar has published extensively in a number of journals, including Past and Present, International Journal of Middle East Studies, History Compass, and so on. And his research has been supported by the National Endowment for the Humanities, the American Philosophical Society, and the Social Science Research Council, among others. Not surprisingly, but, given how exciting it is. And prior to joining Syracuse, he taught at Bard College and was among the team that founded the Economic and Business History Research Center in Cairo, which documented some incredible oral histories, and from mostly the Nasser era. Is that right?
Yes, that's true.
And then Cheta Omar earned his degree, his BA at the American University in Cairo, his MA or AM in Middle Eastern Studies from the University of Chicago, and his PhD from NYU. So I will hand it over to Omar, and then I'll introduce our discussants after he's done.
Thank you for this very generous introduction, Sarah. I'm delighted to be invited to participate in the Histories of Capitalism and Race series here at SOAS. And I'm grateful to Hani Ziai and the co-conveners of the seminar for the invitation, and to Yusra Hussein for serving as respondent alongside Hani, and to all of you for being here tonight. Over the next 20 minutes, I will give an overview of the book. To start, let me situate the excerpts that were shared with you within it, and then state its main argument. The book contains two kinds of chapters. Chapters that focus on structure, which reconstruct the institutions, laws, and concepts underlying the commercial sphere. This includes chapter 5 on the law-defined realm of commerce, which you have access to. And chapters that trace the trajectories of individuals who inhabited and navigated the structure of institutions, law, and concepts. And this is including chapter 3 on Musa and Hassan al-Aqad, which you may also have read. The book's main claim is that the mid-19th century witnessed the establishment of a new mode of market governance centered on the legal reconstitution of commerce. This reconstitution was not simply a technical legal matter. Rather, it contained institutional, conceptual, and social dimensions, which I will outline shortly. But first, let me begin where historians usually begin, the archive. I should be transparent about the starting point of my research process for this book, because it may shed light on some of the decisions I made along the way. What you see here is the main entrance. So I have to comment on it, and so I just say that in spite of its dull outward appearance, the scale of the Egyptian National Archives is impressive. But accessing its wealth of documents is predicated upon understanding its two defining features. First, the archives reflect the bureaucratic organization of the 19th century state. That is to say, for the researcher to know where to look, he needs to situate his question in relation to specific bureaucratic departments. And second, access is quite restrictive, which means that the researcher cannot follow paper trails indefinitely as he pleases, but has to respect the internal boundaries of the 19th century state structure. In the face of this reality, my attempt to write a history of capitalism began in a particular state institution, Majalis al-Tujjar, which I translate as merchant courts. And so it starts there and it branches out from there. This was not a purely free choice, but it was also born out of necessity. And it was later complemented by research in other archives, special collections, and published documents. What you see on the screen above me here is an example of a document from the Merchant Court of Cairo. It's cropped, I know, but I'll tell you why I did that. This document, the form of this document, captures my approach to answering the question of how commerce became legal. The main text is a merchant court decision that outlines and resolves a dispute over an outstanding commercial debt. But I want to ask you to pay attention to the last two lines that follow the main text. The lines that I think someone interested in the dispute itself would be inclined to dismiss as bureaucratic formulae. The penultimate line shows you the names of the four merchants who presided over the court on that day and who made the decision. The last line reads, and Arabic readers might enjoy reading the original as I read the translation, an exact copy to be preserved in the Cairo Merchant Court on, it specifies the date, and then gives the name of the clerk who made the copy, Hamouda Ibrahim, and ends with the seal of the Cairo Merchant Court. These two lines contain within them the three main features of a merchant court. First, the court was a state institution, one that occupied a particular position within the state bureaucracy, referred to state-enacted laws, relied on state enforcement, and whose employees were on the state payroll. At the same time, it was a merchant-run entity where the merchants interpreted the law and, when needed, transcended the law, that is, to rely on current merchant customs, on merchant expertise about ever-changing prices, and so on. Moreover, and that's the third feature, it was a mixed court in the sense that the presiding merchants were Egyptians and Europeans who sat side by side in the courthouse and decided collectively, usually unanimously, on how to apply the law. To put it differently, the last line shows you the existence of a state structure. The one above demonstrates the persistence of merchant authority, which the historiography tells us was dissipated by the process of modern state building. So keep in mind the overlap between merchant and state. And I will just do a brief detour at this point before we delve deeper, because I think it would be helpful for us in the room, especially those not familiar with Middle Eastern or Egyptian history, to get oriented toward the 19th century, which is the moment we're talking about. The 19th century is the most recent major historical rupture that precedes our current moment today for us. It is the moment of global empires and modern state building. The moment also of transoceanic telegraph cables and the consolidation of law regimes. In Egypt, it is the moment of turning a vast agricultural economy into a state monopoly, a cotton monoculture, and its integration into the world economy as the exporter of raw cotton through Alexandria, Egypt's major Mediterranean port. The 19th century was also the moment of the breakdown of the state monopoly and the creation of a free market, also focused on growing and exporting raw cotton. How Commerce Became Legal, the book, begins in the 1840s when the state monopoly broke down and private merchants rushed to take the state's place, thus ushering in the return of a free market, one that needed to be governed in novel ways. It stops, that's still the book, on the eve of the British occupation of Egypt in 1882, which will witness the reorganization of the institutional landscape as the country was integrated into the British imperial realm. So, how was commerce regulated in the middle decades of the 19th century? I created this flow chart of the different paths that money-related disputes scattered today in different archives and document collections followed. Admittedly, it would be more helpful to look at this for longer than the time that our chair, Sarah, will allow, but let me draw your attention to the main point. Not all disputes over exchange were adjudicated under the same set of laws or before similarly trained judges. Partnerships, loans, and sales that served different purposes occurred in different parts of Egypt and between people of various nationalities were heard in dissimilar courts, a point that would have implications for how some accumulated wealth and, by extension, others were dispossessed. I call the repertoire of laws and institutions that regulated commerce the commercial legal infrastructure. And at its center, but to you, it's, I think, to the far left, at the center, or which you see at the far left of the screen, or sorry, far right for you, far left for me, right, were the merchant courts. Now, let us turn to how that commercial legal infrastructure became manifest on the conceptual and social levels. The diagram that you see behind me shows the different conditions that one had to meet in order to have access to the merchant courts that applied Ottoman and Egyptian state laws, allowed for legal representation, a point that I will return to in the end, and sought the expertise of established merchants. If you look to the boxes on the left, your left, my right, you'll notice that access was not straightforward. It did not include every buyer and seller or every instance of exchange. Rather, access followed two logics. The first logic was commercial, whereby people who generated money or borrowed money to circulate commodities were defined as merchants by the law, and so could resort to commercial law. By contrast, those who bought to consume or borrowed to alleviate a financial crisis were barred access. The second logic was non-commercial, and it followed administrative or political imperatives. Here, we see that those merchants whose record-keeping practices resembled those of the state could access the commercial legal infrastructure, whereas others who engaged in the exact same economic activities, but whose records were illegible to bureaucrats, were excluded. Particularly noteworthy is the severance of continuous chains of economic exchange that spanned both the countryside and the urban centers. During these decades, the middle decades of the 19th century, exchanges of agricultural lands and their products were regulated under the land regime and were considered non-commercial. But commodities exchanged between urban-based merchants were regulated under distinct commercial laws. So, for example, debts accrued to fund the cultivation of cotton and then its initial sale to a rural merchant were considered non-commercial matters. They belonged to the land regime. And once the rural merchant who kind of acquired this cotton entered into the city to sell to export-oriented city merchants, the dispute that emerged at that stage around pricing, storage, and shipping, typically to Europe, that the same cotton that was the subject of laws will become now the subject of commercial law. So it's kind of one long transaction, but different laws apply depending on where we are in the process. So far I have tried to explain a repertoire of institutions and regulations that I called the commercial legal infrastructure and the law-defined realm of commerce that took shape in relation to it. For the remaining minutes that I have, I want to give you a glimpse into how actual people navigated these structures. The first person I'd like to introduce is Boutros Tawil, a Syrian merchant based in Alexandria from at least the 1850s and trading mainly in cotton. Boutros, who Gallicized his name to Pierre, which is of course quite common when writing in European languages, had a consistent approach to the structures I explained just now. He kept meticulous records of his business activities in exactly the ways that would have allowed him to resort to the commercial legal infrastructure. Yet he never did so. He tried informal, amicable ways to resolve commercial disputes, threats about future non-cooperation, pressure through mutual contacts, but never the formal legal mechanism that he was perfectly situated to use. There is a likely explanation for this avoidance of the law, namely that taking a business partner to court, a business partner or a debtor to court, is an irreversible escalation. It is the ultimate sign that the commercial relationship between the disputants had ended in the present and in the future as well. Although Boutros never accessed the commercial legal infrastructure, he is a good example of how merchants inhabited the law-defined realm of commerce. His private business archive allowed me to see his economic calculations, mastery of the tools of communication, and network of business associates, which, as you can see on the map, spanned the towns of the Nile Delta, where cotton was produced, and Europe, where Egyptian cotton ultimately landed in the industrial factories of Lancashire. One way in which the commercial legal infrastructure was influential then, that's kind of one argument I make, was that it motivated merchants, even those who would not set foot in a courthouse, to comply with state-sanctioned norms of record keeping. Different merchants made different choices. Hassan Musa al-Aqad, whom you see on the screen, joined the commercial legal infrastructure and made it work for him. not as an ordinary litigant who resorted to commercial law, but as one of the merchants presiding over the Cairo Merchant Court. In that capacity, he played a role in interpreting and applying commercial law, but because of the nature of the merchant courts, which ultimately were ultimately run by active merchants, not disinterested judges, Hassan had opportunities to benefit materially. And as you expect, he took them. Before being a successful merchant, Hassan was the son of a wealthy merchant, Musa Bey al-Aqad, who made his wealth in Sudan in the 1850s. From his father, he inherited status, agricultural land, commercial business links, and connections to Egypt's rulers, the Khedives. His capital, both material and social, led him to a seat on the Cairo Merchant Court. From that seat, he did exactly what Boutros chose not to do. He escalated. He sued former business partners and debtors in the court that he was a part of. He did not preside over the particular sessions where he was a litigant, of course, but he won every time, either because he knew the law well, he was used to interpreting it, or because his peers made the decisions, or, which was oftentimes the case, I think, in my reading of these cases, because his rivals felt, rightly or wrongly, that they would never prevail against him because of his particular position within the commercial legal infrastructure. Hassan, to me, shows how some merchants, generally considered the losers of modern state building, managed to occupy a niche within the state structure from which they participated in governing the market and accumulated material wealth, social status, and political power, albeit to a smaller degree compared to their early modern predecessors. Hassan's tactics were evidently self-serving, but they were not negligent. When he needed legal support, he approached the best legal practitioner he saw at work when he presided over the merchant court, and that's Tito Figari. Tito was not a merchant, but his existence is essential to how commerce became legal. He was born to Italian parents in 1838 in Damascus, when the city was still occupied by Mehmed Ali's Egyptian army. In 1855, at age 17, he traveled to France on an Egyptian state scholarship to study law, and returned in his early 20s to Cairo as a trained avvocato. That was kind of the favored term for legal practitioners from the Italian. He built a name for himself representing merchants of various nationalities who traded in different commodities and who found themselves entangled in a wide range of commercial disputes. As demand for his services increased, he rented an office in El Ataba Square, right in the heart of Cairo's modern section, and recruited 4 lawyers to work for him. With facility in Arabic, French, and Italian, and familiarity with French and Ottoman law, the Ottoman commercial law is derived directly from the French, Tito was part of a new trend of legal representation. From the 1860s onwards, the language used in merchant law shifted gradually from general explanations that with scattered references to laws and regulations to a more technical legalese spoken by Tito and his peers on behalf of occasionally absent merchant litigants. They won and lost cases on procedural grounds or complex arguments that synthesized articles from different legal codes. The rise of these commercial avocatos was a herald of the modern legal profession that would become generalized throughout the judicial sphere, and from which the leaders of anti-colonial Egyptian nationalism would emerge in the early 20th century. These commercial and legal structures and the merchants and law practitioners who navigated them began to fade away in the second half of the 1870s. The merchant courts shut their doors for the last time in 1876, and their jurisdiction was absorbed by the mixed courts, now mixed courts with a capital M, and other state-enacted judicial forums. In 1882, the British Navy bombarded Alexandria, destroying Boutros's city. It also exiled Hassan for his role in leading an anti-British rebellion. Reflecting on the first 25 years of British rule, Egypt's longest-serving British governor, Lord Cromer, declared that his colonial administration had rid Egypt of its 19th-century legacy and made the country modern. However, as I wrote in the book's epilogue, the law-defined realm of commerce persisted without people necessarily recognizing its genealogy. Just a final word. I hope that this selective overview of how commerce became legal gave you a reasonably clear idea of how merchants engaged in exchange-based activities while simultaneously playing an essential role in governing markets at the moment in which the modern state was becoming omnipresent in all spheres of social activity. In other words, I hope that I managed to have placed their economic lives within its social context. So I look forward to hearing your thoughts.
Thank you, Omar. Fascinating and perfectly on time. All right, so we'll hand over to our first respondent, Yusra Hussein, who is a PhD candidate at the Middle East, South Asian, and African Studies Department, MESAS, or SOAS on the Hudson, at Columbia University. Her research interests include questions of Islamic governance in relation to centralization and modernization processes in Egypt and the Ottoman Empire. Her PhD research focuses on the dispensation of justice in 18th and 19th century Egypt, with a focus on Upper Egypt as part of a southern map connected to Africa, Arabia, and the Indian Ocean. All right, I'll hand it over to you.
Thank you so much, Sam. First of all, I have to thank Omar for such a thought-provoking book. I think the book is remarkable in many ways, not just because it's focusing on Majalis al-Tujjar or like the merchant courts, which is not a subject of a whole lot of research, but also because you cannot miss as a reader the thickness of the archives that is used in the work, and how actually you're immersing the reader in the 19th century world, in its logic and sensibility, but also in minute things or not so minute things like language. And I know that we commented on this before, but like Omar chooses to use quotations translated in Arabic to see how people would express small things, small gestures that would show how we're talking about two different worlds between 19th century and now. So congratulations for the book, the publication. It's a great work. I'm done now. So I'll structure my comment on 3 different points. Hopefully I'll get time. The first one is about the historical narrative that the book seems to be building against. So the book focuses on Majalis al-Tujjar, the merchant courts, as a distinct institution in what you call the commercial legal infrastructure of the 19th century, dealing with this sub-arena of commerce and actively defining what to be called commerce and what not, who's a merchant and who's not, and even what's the proper housekeeping norms of commerce and what's not. Like you tell us about elevating something like keeping a ledger for the merchant to the status of accepted evidence, while not making the move to make it accepted as evidence across all legal venues like Sharia courts and others, in doing so, you're contributing to this larger revisionist school nearby. Khalid Fahmy, of course, perhaps to a lesser extent by Rod Peters, which use these short-lived legal systems as part of a longer legal Ottoman tradition that actually signifies no rupture at all. This, of course, builds against a nationalist school of history, mirroring to a great extent the European thought that views what's pre-1880s as a period of legal chaos. So in your epilogue, for example, you quote Aziz Kahil, who's an intellectual and a lawyer himself, and coming just a couple of decades later, and seemed to be completely unaware of the existence or the work of the merchant courts. And I repeat a quote that I think summed it up in your epilogue, saying in the beginning, by Aziz Kahil, saying in the beginning, there was no special law for commercial activities. Instead, the rules of civil law applied to all transactions between people. So deeming it something that wasn't at all regulated. Fathi Zaghloul later in his seminal work Al-Muhammad also dismisses what's before mixed and national courts, which is 1880s in Egypt, which both were institutions modeled after, as you said, French code. So Fathi Zaghlul dismisses the period before as a period of absences and lack, totally unworthy of detailing in his work. In the case of merchant courts, you argue that it would be a mistake to understand merchant courts as a pre and incomplete iteration of mixed courts, or to subsume it to a manifestation of capitulations, the expanding influence of Europeans over the economic and financial sphere of Egypt and the Ottoman Empire at large. So while I understand this work's situation within the revisionist school, I picked on the exclusivity of jurisdiction of merchant courts, which you admit and detail to us in adjudicating disputes that are only involving foreigners, and the seeming power discrepancy between them and the consulars, according to their own litigation, and the Egyptian government in summoning people and enforcing rulings, to be telling of a colonial dynamic. That even if it hadn't yet fully arrived, it did dictate the power relations across different levels. So my question would be, why, despite those power discrepancies and obvious orientation towards serving an expedited process of making profits and securing debts for Europeans specifically, you still emphasize understanding this out of the realm of capitulations? Or rather, you say that it's a bit more. What exactly could you flesh out as a nuance that this narrative and this emphasis would add to us? My second point is the relationship between this new legal venue, the merchant courts, and Sharia, which you dive more into in chapter 5 with detailed and very enjoyable tracing of how the two systems might or might not arrive at the same conclusions, albeit by employing different logics and procedures. Again, I want to tie this to an analysis of a rupture between what's prior and modern legal infrastructure, to use your word, both in terms of the legitimating source of a legal system, but also the difference in procedure. So here, maybe I should invite you to comment more generally in chapter 4 and this revisiting of Sharia versus the merchant courts, which I have to say seem to be standing detached from Sharia altogether in my head, in my reading. I may push it to say perhaps it helped affect this detachment of Sharia even from the whole 19th century legal sphere or legal change. The merchant courts helped detach Sharia. And I see this, for example, in your tracing of Fatawa of Al-Mahdi al-Abbasi, and how while people might ask for a fatwa for a specific thing, it actually held no legal weight whatsoever, but it seemed like a personal curiosity almost or concern. So like more on the relationship between Sharia and merchant courts, and actually the effect of merchant courts on this perhaps isolation of Sharia. My third and last point is about this new category that emerged and seems to me to be carrying a familiar name, but a different meaning effect in ordinary society. So while I was reading, I was thinking of how Samira Izmir speaks of the Hilmi, for example, as a legal category emerging in the 19th century, and how by making it legal as a category, certain punishments and forms of labor, for example, become inhumane, while others, which is the less obvious part, become completely legitimized as humane. So, for example, flogging was limited and deemed inhumane, but imprisonment, even excessively in accordance with Sharia, was deemed completely humane. In this same logic, I'm thinking of this field of commerce in relation to other spheres in society, like agriculture, for example, and how it seemed to take precedence, how commerce seemed to take precedence over agriculture and almost help commodify land, making it secondary to trade and extending credit. So I want to hear more from you about creating this new legal sphere, whether you see commerce, particularly through this new apparatus of courts and laws, serving different audiences as a point and a tool of ordering society that wasn't used in the same way before. Thank you so much.
Thank you so much, Isra. It's really a lot of. All right, and now we will have our very own Hengame Ziai. who is a lecturer in the history of Middle East and Africa at SOAS. And she's currently preparing a very exciting book manuscript, tentatively entitled Archives of Crisis, Political Economy, Islam, and the Mahdist Uprising, that interrogates fascinating questions around the relationship between religion and the economy from the Sudan. I'll just say a personal note that I got to read Henny's manuscript ahead of reading Omar's a few months apart, and it was fascinating to see the ways that they speak to each other and how reading them together actually was very helpful for reading both. So it's lovely that you guys can have that conversation. And she has also published numerous peer-reviewed articles in journals, including Critical Times, Rope, and Comparative Studies of Asia, Africa, and the Middle East. This year, she holds the Oxford University Coach Research Fellowship. With that, I'll hand it over to you, Hen.
Thanks, Sarah. Thank you, Omar, for sharing your work with us. As you know, it's one I've been desperate to get my hands on since I heard about it. I heard about the dissertation. I couldn't read that, couldn't access that. So I was really thrilled to get a copy of this. And your book, as Yusra has said, I should preface my comments with how terrible it is to go after Yusra. A, she's so brilliant, and B, I think in quite similar ways. Not that I'm saying I'm brilliant, but we think in very similar ways. So there might be some element of sort of repetition in what I'm about to say. So your book was extremely archivally rich, and it, for me, shed light on a world that I've been very, very anxious but unable to access. So this generation of historians or amateur historians who want to actually get into the Egyptian archives and have not actually succeeded in doing so. I think this has been extremely eye-opening for us. So the first thing I want to talk about in terms of my reflections on the book, it's I'm also going to do a bit of sort of situating as I see it. So the story of legal transformation in 19th century Egypt has been surprisingly obscure. And I think to some extent it remains, it has its obscurities. And as you mentioned in your work and in your presentation, many of the sort of pioneering legal historians of the late 19th century and early 20th century perceived the 19th century under Khedive rule as a forgettable period. They erased it from their accounts. So, before the onset of British influence courts, the mixed courts and the national courts set up in the late 1870s and 1880s. So before the onset of the modern legal system, what existed before was considered chaos, despotism, or perhaps even a kind of European mimicry, an attempt at European mimicry. So your work, building on the work of people like Khalid Fahmy and many others, has showed this chaos to be very much far from the case. So it departs from a history of absences, which has structured a lot of history writing, not just with respect to Egypt, but the broader Middle East, West Asia, Africa, and meticulously and patiently reconstructs how things actually operated. As I understand this sort of literature, until your book has come out, the juridical landscape in this crucial period between the 1840s and the 1870s was understood to have been composed of this bifurcated legal structure. So the Sharia courts on the one hand, and this network of what Fahmy called siyasa councils, so government administered councils, two halves of juridical process working in tandem. So we knew that there was this phenomenon called the Majlis al-Tujar, so the merchant courts in your rendition, but we actually knew very little about how they function. So I've also come across them in sort of ancillary references, but there was no sense of what this institution actually was, how it worked. And in your work, so you've used these court records from the National Archives to actually lay out for us their functioning. And so for me, you have in some ways completed a missing part of this kind of juridical landscape as we understood it. And you've done it with such sort of rich, almost ethnographic or like historical ethnographic detailed, showing us that the merchant courts were not this kind of static and also sort of preconceived sui generis entity, but were at once rooted in earlier mercantile traditions of adjudication, but also subject to epistemic changes associated with the rise of modern government. but also were transforming, or I don't like this word, evolving between the 1840s and the 1870s. So you tell us about the rise of the figure of the advocate or the legal representative, which didn't actually exist in the early years. So for me, in some ways, you're completing Fahmi's story through this book. The second thing I sort of want to turn to is the spatiality of this text, because the world you depict for us is, I think, far richer than maybe the subtitle "Merchant Governance in 19th Century Egypt" might at first suggest. So if someone were to take that at face value, it might be misleading. So, the chapter on Boutros Tawil offers a picture of a Mediterranean-directed commercial world. By the time we get to chapter 3, you're talking to us about the Al-Aqad family, so merchants who themselves were, you said, likely from Upper Egypt, so which means southern Egypt, and whose activities were actually facing Sudan. So it's incredible to see, for me, as someone who works on the history of Sudan, how much capital was accumulated in this period through commercial transactions taking place in Sudan, which I would argue was also subject to the same kind of legal juridical universe that you outlined for us in Egypt. And I should also add, how much capital was accumulated through also the forms of violence that were taking place in Sudan in this period and elsewhere. So I think your work confirms for me the importance of reading commercial and legal transformations in these worlds within a single frame. So this takes me to sort of my last point, which is a slightly bigger point, which is about the kind of conceptual intervention that your work is making, which is the most sort of scintillating for me. And it's one that your book really builds up to in the last chapter. I think chapter 5 is actually called Concepts. So I see you as sort of charting the development through legal interventions of this distinct sphere of the commercial, deliberated and delineated in the merchant councils from other social spheres. And these other social spheres were in some ways engendered by the councils as the outside of commerce. So we might, one sphere might be agriculture, another sphere might be the personal. So I think Yusra has also talked about the separation between sort of commerce and agriculture as key. So my thoughts on this are, so on the one hand, would you say that what you're offering is a kind of account of a legal discursive construction of the commercial, as a sort of bounded sphere, one that doesn't actually exist in another discursive universe, which might be the Sharia and Messick's works, which was like a total discourse that sort of encompasses areas that now we might divide into the private and the public, the commercial and the agriculture and all the other sort of spheres. So is this a kind of discursive production through the language of law? And I'd be really curious to hear you spell out what are the implications of creating this sphere of the commercial. Does it subsist, which I think I heard you say in your presentation, or does it die with the death of the Majlis al-Tujar? But perhaps more broadly, I'd be curious to hear how you would articulate the place of the law or the juridical in the study of, on the one hand, capitalism, and on the other hand, sort of epistemology. Okay, so on the one hand, it seems like the law is key to the reordering of material practices. So these material, reorderings are engendered by these juridical interventions, allowing for forms of accumulation and so on. But also they're creating new conceptual worlds, new sort of conceptual separations. So they have kind of epistemic effects. So the material and the epistemic vis-a-vis law is something I'd love to hear a little bit more about. And let's see how I'm doing. Time for maybe just one more point. So Fahmi's made a lot of the fact that what we saw in the 19th century, as Yusra said, was a kind of indigenous form of legal modernity that can't easily be mapped onto European categories. It's a system that defies neat assimilation into European legal process and progress, rather. But in your text, Europeans are very much still at the heart of the story. You sort of, made this point. the agriculture is excluded, and perhaps one reason for that I think we discussed right before coming into the room is because it allowed European the courts were set up to facilitate European merchants being able to sort of collect their debts from locals essentially. And it's an interesting thing because we know how much wealth was derived from agriculture by both Egyptian and Sudanese elites in this period. So is it fair to say that your work actually complicates Fahmi's account of an indigenous Egyptian legal modernity? Are you offering as a sort of middle ground here? So even as the juridical developments are emerging according to their own logic, maybe are indigenous, they are nonetheless subject to European pressures, the pressures of kind of enforcing credit, and so on. So I think I'm gonna stop there. I have one more point, but I might save it for Q&A.
Amazing. Thank you, Hani.
Great.
So not much to work with there. For you to respond.
I just want to confirm you said I don't need to cover everything, right? Okay. Okay, let me start from that last point and speaking to both of you at once. I didn't think of this as offering a middle ground, but it does reflect, I think it reflects two things about my approach. The one is a certain, to quote E.P. Thompson, kind of poverty of theory. I'm the poor figure here. But I didn't, I think, start with a whole lot of conceptual thinking. I mean, there's some conceptual, of course, thinking that one cannot escape. But I started more empirically than conceptually. So I wasn't thinking of middle grounds, and I wasn't thinking of how harmonious or symbiotic the legal system will end up, which is ultimately, I think, what Khaled Fahmi's In Quest of Justice and so on offers. But I start from a different. I started from a different kind of concern. I was maybe. I think because I'm aware of how much the question of European capital versus native capital and so on, indigenous capital and so on is a big question that dominates that dominates the field. And I remember one time I was as I was presenting on a similar topic a few years ago, I typed a word that I think an expression that I think is very common in the literature, which is kind of basically European penetration. And it kind of, you can see on Google Scholar, all of these it comes up because it's all about basically the European capital penetrating these economies or economic fields, and then working in such an uneven way because of the capitulations and so on. So I basically was a step, I think, ahead, beyond, which is to say the capitulations are there, and they're a part of the legal system, they're a part of the legal landscape. And yes, they're uneven and they reflect, by that point, not in the early modern moment when they began, but in the modern moment, they reflect an unevenness, they reflect an advantage for European capital, they reflect an advantage for indigenous capital that gets affiliated with European consular subjecthood or kind of protection and so on. So this is all to be taken for granted. My starting point is the capitulations actually were maybe, yes, on some level, taking it for granted, was facilitating European capital kind of, capitalist kind of expansion and so on. But at the same time, simultaneously, it was getting in the way because there are so many jurisdictions coexisting at the same time, and none of them can be placed above the other. And then there's a huge problem of enforcement. Because people get sued or kind of, decisions are made in this court or that, and then no one can really summon anyone into a different court. And so the crisis emerged, the crisis emerged with the breakdown of the monopolies, because up until when there was kind of these large state monopolies, up until 1838, 1840, 41, etc., the government's legal infrastructure was not concerned with disputes among merchants. It was concerned with disputes or irregularities between state bureaucrats and merchants. The fear was that the bureaucrats would not be doing their due diligence and giving preferential treatment to certain landowners. So it was a question of corruption, not a question of recouping unpaid debts or kind of figuring out whether, statute of limitations questions on things of that sort. So at the monopolies break down, there is this influx of kind of rapid increase of private merchant disputes and no mechanism to resolve this. Too many mechanisms, but none of them is all-encompassing. And so the merchant courts emerge as a compromise between, or a diplomatic agreement between many different European consulates and the Khedive government, who basically said, the European consulates said, we're going to give up a little bit of our advantage, which we have, in order to create one system. And the government said, and we can basically use our capacity to enforce and our kind of presence throughout Egypt and so on to make that system work. And the price of this was some kind of mixed arrangement where European and Egyptian merchants sit together and rule according to this arrangement of laws and so on, Ottoman French regulation, and so on. So this is how I see where the capitulations are. It's not dismissing their importance, but it's actually saying, this is not only about exploitation, this is also about getting in the way of exploitation, right? It would only work, the system would only work in whatever ways uneven as well, when there is some kind of unified, consolidated legal space.
Maybe just one.
Yes, one more point, yes. And I don't honestly have much to say. The other question is the one about land. I was a bit surprised, but I see the point of thinking of the land regime being secondary. I think what gives this impression, and I might just have to do with the focus of the book and me not being very, very careful. But my impression is that the law regime was the priority. Issuing a land law in the 1850s, moving from rights of usage to private property, and then that laying the ground for all kinds of financial schemes that are tied to land, mortgaging land, and so on. This was the big deal, and there was a fear that because of that compartmentalization, as you said, of the legal spheres, dividing them by activity and so on, is that this will interfere with a uniform land regime. And the pressure, the internal pressure, was coming from the land-owning class, not from the merchant class. And so the land regime was created, and it was created in a way that, in fact, circumscribed the commercial sphere, pushed it fully into the urban areas, and made it only relevant after the agricultural process and its initial related commercial activities are completely done. And then the sphere of commercial law begins. The reason maybe why, and I see why you say this, and now I'm actually rethinking it, is that merchant courts did end up in practice interfering in the land regime through confiscating land when there were outstanding debts and land was the only possible asset to be liquidated. And so in that sense, yes, we can see how commercial law actually ended up encroaching into the countryside. And I didn't look at this systematically, but I wouldn't be surprised to think that the emphasis, back to the first point, on allowing European merchants in particular to, because time is of the essence in a credit, on an commercial economy running on credit, you can't wait forever to recollect your outstanding debts and so on. So liquidation or confiscation, liquidation, and so on becomes a final and kind of definitive solution that will solve the problem. So maybe this is how kind of European influence or European capitalist influence kind of encroaches back into the land regime. But this is not developed here. I'm kind of thinking with you as I hear this. So thank you.
Thank you very much. All right. So with this wonderful kind of start to the conversation, we're actually going to hand it over to you guys. So any questions, comments, you can direct them at, anyone on the panel, but also towards each other. So that's Lubna.
Okay, great. This was really great. And this is a version of these questions, but an ignorant version. Because I just was struck, I'm far from an expert in any of this, but I thought that commerce was always legal in Islamic jurisprudence because, Sharia was, it sounds like you deal with this in the book, and I haven't read the book, so you can just tell me read the book. But so just to make this a bit more interesting, so I wonder, so it sounds like what's going on here, and I'm just picking up on something else I said, that the issue was that the Sharia courts put it under civil other things, or that it wasn't a specialized court with specialized experts that ruled of it, and this is what's special about, this is what's distinctive about these particular court. So it was thinking, and sort of relates some discussions you were having about whether it would be interesting to see which cases were disqualified from being seen by those courts. And again, maybe that's something you talk about, but because if it what's going on here is a sort of delimitation of what we call commerce that wasn't delimited in this particular way because maybe it overlapped with agriculture or whatever, So is there a sense in which, like there's cases that count as like, yes, this is under jurisprudence of these courts and not, and that sometimes gives us a sense of whether there's continuity with what's before, or a sense of like there's something new here because these things now count as commerce and these things don't. And do you see that in those cases?
It's in the back. Yes, yeah.
Okay. I was just going to ask for like a clarifying question. I'm not in the list. I wasn't sent the. Maybe this is already in the book, but the way you describe specifically the way that capitulations were actually in the way of commerce and the legalization of commerce was fascinating to me because of I work on tangentially work on extraterritoriality and capitulations when it comes to criminal jurisdiction, which has always been the domain of exclusive sovereign jurisdiction. But there were attempts, there were discussions around internationalizing criminal justice, which was met with so much pushback on the part of the European authorities. So it just made me realize, as a precursor to that idea of internationalizing any kind of jurisdiction, there's the internationalization of commercial jurisdiction in your case, which was actually a very much it wasn't necessarily because of European colonialism, but because European colonialism was getting in its own way, that commercial justice in a sense was internationalized. And is that your point? Is that a bigger point about the genealogies of the mixed courts and international commercial courts?
Yes. I'll say something about it when it's my turn. I'm not allowed to speak yet.
So I've got probably quite a hard question, but maybe I'm going to direct it to all of you and anybody else in the room who's also working in this area. I am myself working on a project on 18th century cotton in South Asia. So I cannot wait to read the Buttress chapter. I read chapter 3 and chapter 5 that was circulated. And I guess I wanted to know whether or not in your archives you see different forms of the human that are actually quite distinct from what this new legal framework of modernity, the merchant courts, what kinds of conceptions of the human are actually underpinning it. And if I break that down, the way that I understand the cotton economy to be working in South Asia and the beginning, the decline of cotton and the sort of beginning of modern commerce, that story in South Asia very much is about this notion of the human who owns labor, who owns their own labor, and they mix it with nature and they make a commodity, and you take that commodity to market and it has profit. Now, that very basic understanding of the economic human, to me, the relationship there between the human and the nature, or human and the property, is dominion in the legal systems in the British system in South Asia, and I imagine also in Egypt. But in the Sharia system, it's milk and it's a whole range of different things that milk means, which seems to transform. So I wondered, you know, this idea of the human, that Lockean idea of the human that ends up then underpinning, you know, Adam Smith's labor theory of value and Marxist ideas and so on. Do you see another form of the human that has a different relationship to land and milk? Does that continue to be animated as a concept in these merchant courts, which I can't help but hear as a transitional space? I'm trying to hear your you know, warnings against reading it as a transitional space, but yeah, that and this is a question for all of you who are working in these archives of Sharia, you know, and its European penetration or not. And I guess my question would be, if there isn't any other form of dominion apart from the European forms of dominion, then isn't it just penetration? If notions of milk of that sort don't actually carry on.
Well, thank you very much, Sarah. My name is Ali Soliman. I used to be a government official of Egypt, so very much interested in your history. I guess you are talking about a very short period of time, between 1840 maybe and 1882. When we talk about Egypt, we normally talk about centuries. And I want you to go back 10 centuries back and look at how commercial disputes were being resolved. And the Sharia law has a very unique institution called the Muhtasib. Muhtasib is a government official that resolves disputes. And this was very common even in Islamic Spain and other places in the Middle Ages. And the other issue I have with your title, first I want to thank you for this fantastic work going into the archives. That's work of real heroes. I mean, who fight bureaucracy and try to get the documents out. But the word how commerce became legal is kind of annoying a little bit, because I thought Egypt had always a legal structure for commerce. And if you look at the Middle Ages, where the spice trade was coming from India and going to Europe through Egypt, it was very well organized and it had its own mechanisms. And that takes us to the concept of modernity, especially when you mentioned Lord of Cromer. And for him, modernity means to be a dependent economy to the West, for him. And that doesn't mean that the legal system, the old one, was not efficient or it was not viable. And actually, I am interested in the history of Islamic Spain or Andalusia. And it had a very vibrant international trade, while the rest of Europe did not have in the 12th century and 13th century and 14th century, because of the legal system and because of the control of the markets that we had. And they were able to create excess value through export and so on and so forth, while Europe did not. So the word modernity had to be taken with a grain of salt in this respect. You also mentioned capitulations and the entrance of European traders and so on. But I had a comment about what you noted about Boutros or Pierre, who did not go to the courts. And if you read about some of the personnel of the minority traders in that time, they were very averse to go to any court. And they want to resolve the disputes inside the minority, whether it was Jewish or Coptic or whatever. And they were willing even to pay a compensation to others in order not to go to court. So it's not a strange behavior, given this, from his name, I can say that he's a Coptic Christian. So again, perhaps if you extend your historical perspective a little bit, we might be able to resolve some of these issues. Thank you.
Thank you. I have to admit, I only read the first 10 pages of those excerpts, but I was very intrigued. And congratulations on what seems to be an amazing book. I'm not a historian, so please take my comments with a grain of salt, or they reflect my ignorance quite clearly. But I'm wondering to what extent this transition, this transformation you're talking about from commerce to legality reflects a transition from the relational governance of Sharia, a system based on sul, tahkim, the resolution of disputes in which parties do not necessarily win or lose, or at least they don't win or lose outright, such as in litigation where it's an all or nothing game. And the introduction of legal structures premised on the European model, very organized, hierarchical, delineating instances of authority, directing disputes on the basis of this categorization, which indicates a focus on Western systems of law that are premised on individual transactions that are based on adjudicating disputes and bringing to bear rules of law with respect to any specific dispute. Whereas in the Islamic tradition, it's not so much about the individual, it's about resolving a dispute so that the member of society is made good, so that society continues to work in a way that is at peace with society, so the enmity is not created. I wonder what your view on that is.
All right, we're gonna take one more question.
Hi, thank you for the talk. Apologies, I've got a bit of more of a Q&A one than discussion one. I was wondering in these courts, how the concept works of a legal person. I think one of your examples, for example, has a company, and I wonder, in terms of debts and liquidation, how that comes into it, if it's assets owned by individuals or company assets, and how does it work as a legal person? Are companies ever brought to these courts, or is it only sort of, interpersonal?
No, that's a great.
All right. The floor is yours.
Okay, this is actually more challenging than I thought, because the different I kind of want to deal with different questions at the same time, but I wrote them obviously as a list, and now let me start maybe with answering Lubna your question, because it might clarify some angles that I want to deal with later. I think this is an excellent question, and this is ultimately what I did. The way I defined, and I'll come back to this issue of modernity and what's new and what's not. But this is how I defined what this new legally defined realm of commerce and so on. I defined it negatively, exactly as you anticipated, by tracing the cases that were dismissed by the court as being outside of its jurisdiction, or and this is how I built. So I guess one thing that wasn't clear from my presentation is the kind of empirical, kind of ground up work, which is and then kind of claiming a conceptual change in the end, because it doesn't come from a conceptual or reading kind of theoretical works, and kind of working my way down. So I'll give you a couple of examples of what these disqualifying, kind of dismissing decisions look like. The merchant courts would hear cases about, let's say, debt, or a contract that was not respected, or something of that sort. And the first thing that they would verify is the person asking this, yes, this person is in debt, or this person's a creditor, or whatever, and yes, this transaction happened. But is the person who's bringing the claim a merchant or not? If the person was a government employee, by definition, they said this person is not a merchant, we cannot look into the case. If the person was a merchant, but not someone who kept a ledger and regularly recorded kind of dated and legible transactions and so on, this person is a merchant, of course, to his peers, But in the eyes of the court and commercial law, this person is not a merchant. And they would say a very striking, this was one of the kind of first revelations for me in the archive, is that the court decision would say, لَيْسَ مِنْ زُمْرَةَ التُّجَّارِ. And so kind of, we're not going to hear it, go somewhere else, go to the police department. I don't know, you figure it out. The other thing is distinguishing between civil and commercial debts. So, okay, there is a debt and there is a contract and there is interest involved and all of the conditions are there. But why was the money borrowed? Was the money borrowed to buy something that's going to be consumed? Was it borrowed in order to build a house? Was it borrowed because someone was in debt and was trying to get ahead of the debt by just borrowing from someone else and so on? All of those would be considered non-commercial. The commercial debt has to be linked to a process of circulation. If the person is borrowing money in order to buy, in order to sell, and then this is how they would pay and so on, this would be a commercial case, and so on. And then there's issues with inheritance, enter into the thing. I gave the example of agricultural transactions and so on. So this is how that realm is kind of comes into my view. And this differs from Sharia, which is the next point I want to say something about, because Sharia is a universal kind of legal discourse, right? It's going to rule over different things according to different, rules and so on, but it's not going to turn anyone away because there's a technical distinction between the commercial and the civil and so on. It's all within the purview of the judge. So let me clarify something as I speak about Sharia, and cut me off when it's time, because I now have no sense of time. I don't describe, I am speaking about a short period of time, you're right. And this doesn't offer kind of the long arc of economic development. But the moment I'm writing about for a reason, is that this to me is a part of, these are decades that come relatively early with the uneven and gradual encroachment or introduction of a modern legal logic into the government bureaucracy. I don't say modern because it's better, and I don't say modern because it's an East versus West question. I say modern because I'm describing modern here as a process. So modern law, for better or worse, what it does is it rejects universal jurisdictions, universal jurisdiction for maybe the government, the sovereign, but it compartmentalizes, which Henny is a point you picked on, it compartmentalizes different areas of social activity and tries to deal with them separately, following kind of different regimes of evidence and so on. And this is very disruptive. What this does basically is that it starts to, for decades, it starts to overlap with existing and more expansive and total legal spheres. This pertains most importantly to Sharia, of course, where we start to see now by government decisions going to Sharia courts saying, you can't look into this case. If this case comes to you, we're not going to enforce it, and so on. So the Sharia court system, although physically on the ground, it's everywhere. And although, as Dr. Sulaiman also kind of correctly stated, it had answers for all of these questions, and you said the same. Of course, it facilitated commercial activities for centuries. But at that moment, it was basically being denied the ability to see these cases, not to see them at all. And I think, Yusra, you corrected me on that earlier. But it can see them, but the government won't enforce. And so in that sense, it kind of disarmed the Sharia courts in relation to commercial cases. So this is on, I guess that's an incomplete response, but in relation to this issue of Sharia and modernity. The other thing, in relation to Sharia, is that Sharia itself as a pre-modern and kind of established legal sphere, network of courts, legal discourse that has its ways of regulating itself and so on, becomes also in that modern moment, again, not to praise modernity, but becomes something that is being forcefully codified. And as it becomes codified, its nature changes. It becomes unable to function effectively in a modern moment. And it also becomes restricted at the same time. It basically transmutates because it becomes restricted from all the way the Ottoman government to the Khedives and so on, established the position of the Grand Mufti, basically, who's a Hanafi. And they say, every decision that comes out of any court has to be consistent with Hanafi fiqh in particular. But then the Grand Mufti needs to figure out which Hanafi opinion to codify, because within every madhab there is a range of answers. And so he starts to collect some majority decisions or kind of opinions with some minority opinions, makes kind of his own synthesis, which he feels will work. So the Sharia is not the Sharia of old, it's a new Sharia. And then the government integrates muftis and other positions within these councils, but not in commerce. So that's one very quick response. Unfortunately, it's a limitation of my work. I'm looking at the cotton economy from the city. So I'm tracing how money travels from the city into the countryside to buy crops that had not been grown yet, right? Or to fund the agricultural process. And then that awaits the product of the agricultural economy to arrive in the city. So I do not see, unfortunately, what the human experience looks like on the ground in the fields. Okay, so that's something that's outside of my purview, which is the way I can't answer the question. I wish I could. Can I answer two quick questions? Do I have time? Okay. Sorry, in which order should I go? Yes, on the capitulations, I think of kind of revisionism as the ethos of, the historical enterprise. But I was earlier when you said revisionism in relation to Sharia siyasa and so on, I wasn't thinking of revisionism in that sense, but actually in relation to what you were saying, which is how the criminal sphere, the sphere of criminality and criminal law, penal law, and so on, is what we have in mind when we think capitulations, because it does actually very clearly shield European subjects and kind of messes the way that kind of justice can be carried out. In relation to the point about the individual and so on, I see what you're saying. I don't think, but sadly, without too much elaboration, I don't think this is, I understand the idea about the totality of Islamic law and kind of thinking about the person and the harmony of community, not the individual right and so on. I get this, I don't disagree with it. But in the commercial sphere, I think it's different, because even modern commercial courts favor and have mechanisms for all kinds of they're not non-legal, they're legal, but solutions that are out of the court. They create assemblies of merchants to arbitrate if they can, or if they need to. You see cases that stop mid-point, I think, because the litigants arrive at a decision amongst themselves, which is probably because they went to court necessarily not to go all the way, but to pressure each other to sit down and speak and so on. So because of the nature of the commercial logic, and because it works through credit and unfulfilled promises and waiting and so on, East or West, modern or pre-modern, merchants don't want to go to court. They'd rather they want to resolve, even if in an incomplete way, even if they forgive a part of a debt and so on, because there is the promise of going back into partnership with one another. Whereas going to, let's say, court and imprisoning a debtor you don't get anything out of it, maybe except if you can be vindictive and feel good about it, and I'm sure they did, but it doesn't facilitate the economic angle. 1 second. No. Okay.
Fine.
The legal person not in Sharia. But in Ottoman commercial law and so on, it depends on what kind of partnership. If the partnership is about, if the partnership might be a kind of partnership where the liability is shared equally, and each one has to pay half through liquidating their assets. Others treat a limited liability kind of option would treat the partnership as kind of an entity on its own, and so there is like a whole range of this that is solved according to the contract and the law and the particular kind of partnership and so on.
All right. Thank you. That was very well done. Let's move to another round of questions. So the floor is open. Yes.
So a non-academic question. So the from the little that I understand, the measures Tajar seems to be close to the idea of commercial arbitration in the modern world, in the sense that you take these disputes out of the dominion of the traditional courts, and you give them to people who might have a more of an economic or commercial expertise and familiarity with the issues and disputes. And I'm wondering, because in the modern world, commercial arbitration is usually looked at as the state giving up part of its sovereignty in order to attract capital, among many other reasons. But one of the main reasons is that in order to attract cross-border capital, you don't want necessarily to make the investor or the bringer of capital, the capitalist, abide by your own laws, and at the same time, that person does not necessarily have the power to compel the other person, the other commercial partner, to comply with his or her own laws. And therefore, there's this idea that you choose a middle ground, which is something that is outside of the dominion of the state. And it's usually seen as sort of a compromise or a concession, rather, by the state in order to attract capital. And it kind of seems to me, from the very little that I know or that I heard, is that it was sort of the reverse, that it was the state taking rather than the state giving. The state taking from the merchants rather than the state giving the merchants. I wonder whether this idea of like attracting people who have capital and making it maybe a more predictable system, so to speak, and maybe a system that has the power of the state to enforce, whether this notion of trying to attract capital from different parts of the world was any part of it at all, or whether this was completely alien.
Welcome back. I've got a bunch of comments and questions, so I have to really hold back. But some of them are actually responding to points that people have made in the audience. So I think I just want to reiterate something that you said that also came to my mind in response to, I think, Dr. Suleiman's point about commerce having always been legal. It seems very important to me to say that law is not law is not law is not law. So what I understand to be legal in the title of your book is, as you said, specifically the modern legal system that is characterized by an increasing centralization and an authority that is coming top down, that form of enforcement that is coming top down. And this is something that appears to sort of intensify until we get to the mixed courts and the national courts, to the extent that other epistemic frameworks or ways of other legal epistemes, or I would say juridical epistemes, come to be eliminated, right? So legal here is very much the centralizing modern state. And so that's the commerce that is becoming legal. And so this kind of also just led to a question for me, which is, if we're to understand the pre-modern Sharia as a very different kind of episteme that, for the most part was decentralized, for the most part wasn't enforced top down, what are the Sharia sort of epistemic categorizations of commerce? Does it even have that? You know, is there some kind of conception of the merchant, the tajir, or is it just that anyone who buys and sells is subject to the same kinds of laws? I mean, obviously, there's the very, very broad category of mu'amalat that encompasses all sorts of forms of transaction, including sort of marriage and divorce and so on. So, I mean, rather than, of course, it's a very obvious point, rather than seeing that as a weakness, I mean, it almost seems like a starting point. This, I think, speaks to your question a little bit, Samia, of these kind of different worlds, different ways in which people understood themselves or the idea of the human that comes to then be restricted, in this case, to the figure of the merchant that is like legally top down, delimited. Yeah. So any sort of comments that anyone might have or you might have on alternative ways of thinking about the commercial, if it existed at all as a, you know, circumscribed sphere. And then just sort of taking the conversation in a different direction. We've discussed this informally, the three of us, but I don't think it's come up as strongly. But one of the amazing things that your you know, book provokes us to think about is the ascendance of the epistemology of the text and textuality and writing and the kind of written how did you put it, sort of the trail of writing that gets sort of left behind. And I think that's a really interesting thing for us to reflect on. So you talk about the convergence between, you know, this the Majlis al-Tujar, the commercial courts, and their focus on writing as a form of evidence, but also this maybe transforming Sharia system that increasingly is privileging written forms, even though historically it has been, you know, based on a sort of oral epistemology. And so, yeah, what are the implications of that in terms of how people are operating in the 19th century? Is it not just that commerce is being legally defined, but is it also that society in general is becoming more transactional and commercial through, you know, legal sort of interventions?
Cheta?
Yeah, well, thank you very much, Omar, for a fascinating book. I didn't have a chance to read it yet, but I will do so soon. I mean, my question, it's a very simple one that touches upon several of the points that was raised already. I'm curious about the nature of the commercial activity that is subject to this court. I mean, what qualifies, what disqualifies the activity? Only because, I mean, that there's, I think Samia's point was about that continuity of economic activity.
Yes.
That
Yes.
is difficult, and that you brought up collateral specifically, which messes up everything. It brings in people, it brings in property. So I guess, I mean, how is this even defined, where that commercial activity begins and ends? Who decides that? Is it part of the Majalis's activity? I mean, do they do that themselves? Yeah, I mean, I guess that's about it.
Thanks.
Samia, you wanted to come back in?
Yeah, I mean, I guess both Cheta and Henny's points kind of clarify what I was trying to ask, and I'm going to rephrase it not as about the human, but about the history of the idea of property. I wondered if you could tell us about how, you know, this rupture moment that you're talking about, and then does the idea of property actually stay consistent? What constitutes a commodity? What constitutes something that is considered private property? Because I guess that's I want to understand what it ruptures from. We know what it ruptures to. What does it rupture from, or is that not something that is actually visible in that merchant court archives?
I'm going to use the chair's prerogative.
Jump
in.
Okay.
Because I'm loving this conversation. I've been, first off, wow, amazing book. And when I was reading it, had to read your tables maybe 5 times to make sure I was reading this correctly, right? This idea that commerce, land, like who goes where, and really kind of, because in my mind, when I teach, these classes of property, debt, so on, all of this is so interconnected, right? To Jada's point, to Samia's point. When did they decide what was merchant, like what was commercial, what was, because these actually very people are also landowners, they're also traveling to these spaces, right? And so I had two sets of questions. The first set kind of brings this conversation to, actually, we had Neda Mumtaz here a few weeks back, right? And she has this fascinating kind of intervention around thinking about the delineation of religion economy through the space of the waqf, right, as property. And as one way to think about, what becomes over time seen as different ways of thinking about what is property, what is commodity, what the role of, and what we can siphon off as personal, as religious, and then brings us, to the Sharia courts, to the civil courts, and how that process, I mean, she's really interested in what sort of, in a similar vein in what you're doing, right? And tracing how the process kind of unfolds. And to me, I'm gonna revert back to my discipline a little bit and ask about power dynamics, right? So you actually, in your answer earlier, did tell us that, like, the landowning class was the class that really wanted to make sure that land stands outside of the Majalis Tijara, right? And I thought that was very interesting, because I'm sure there's also another layer of, like, thinking about not just thinking about waqf and land and sort of private property and all the power dynamics that are happening there, not just with like a particular class of landowners, but also the role of, I guess, religious institutions that have stake over waqf, for example. And so I actually kind of was thinking along your lines, in the sense that the fact that these things stay out of the merchant courts is a protection, in a protection kind of against the infiltration of European kind of commerce into the, or power, at least in the capitulatory system, into all of these domains. So I just wondered if what your thoughts are around especially this question of power and property, religion, economy. The other thing that was just fascinating, because I like to think in terms of geography, was the spatiality of your tables, right? And someone brought it up, I think maybe Henny. Because to say that it's urban rural, I was, you're thinking about this, the movements of actually the properties, the commodities, the actors that they're coming into these ports, the cases are actually not necessarily always urban, right? In a sense, they're quite interconnected to a huge geography. And what I instead saw kind of a privileging of something like maybe mobility, and a particular kind of, life in a particular way around kind of movement and so on, versus, and then kind of engagement with a particular kind of class, etc., as opposed to saying there's a clear urban-rural divide. I think you're not saying that, but I wonder if you wanted to tell us a little bit more about, like, the spatiality of what of the cases that are coming in. Henry.
I had a question about the relationship between, yes, broadly the law and commerce. I've been sort of I was interested in the way that both you and Henny were sort of glossing how you understand the nature of modern law and what makes it sort of distinctive. And I guess just based on the title alone, it sort of would appear as though your story takes commerce, the institution or entity of commerce, to sort of be this kind of self-same entity that persists over time and then becomes legal. So the law kind of acts on or sort of transforms a sort of a phenomenon or an entity or a subject, object, commerce that persists over time. And so, but I wonder if it might be possible, I mean, to conceive of commerce instead as that which sort of allows modern law to emerge as law. And I guess what I mean by that is on the one hand, yes, modern law is sort of it is centralizing, it's sort of universal, attached to the power of the state. And on the other hand, what distinguishes it from something like Sharia is that it is meant to be sort of restricted to a sphere known as kind of the law, right? So it's meant to leave alone issues of sort of morality. And here perhaps is where sort of the kind of Lockean theory of sort of the human and the separation between that which the law is meant to have sort of, jurisdiction over and that which is meant to be left to, say, economic man, that division sort of emerges. And what I thought was so interesting was that in these commercial courts, what defines commerce, as you sort of described it, is that it has to be sort of ongoing. It has to be a commerce has to be about circulation, and it can never sort of come to rest. In that sense, it's meant to be a sort of purely kind of universal, a sort of pure economic sphere of continuous transactions. So I wonder can we understand these commercial courts as sort of almost like the exception within the law that is meant to deal with the, let's say, purely economic, that then allows sort of the law itself to emerge as this sort of restricted sphere that is counterposed to the sort of universality of economic man? Are these sort of, is it just that sort of commerce became legal, or is commerce what allowed the law to emerge, I guess is the question.
Yeah, I'm very excited about reading the book. I haven't read it yet, but I will. And I just wanted to follow up on the conversation on land and property. In particular, you said something towards the end of your presentation along the lines of the merchant courts, the law of the merchant courts continued without people knowing its genealogy. And then earlier you said that the mixed courts absorbed some of the work of the merchant courts. And I was trying to think about the mixed courts regulation of property, of private property, because the point of the mixed courts was to regulate disputes that are of mixed interest.
Yes.
And anything that is foreign interest would go under the mixed courts. And private property was deemed automatically a mixed interest, even if
I missed the last part. That was just
the mixed courts were supposed to regulate
mixed interests.
And private property was deemed to be something that is necessarily a mixed interest.
By definition, okay.
Even if the two parties are Egyptians. So anything that pertains to property disputes between them would go to the mixed courts. And so here we have a very clear shifting of the power question by actually the legal system or the mixed court system directly says that anything related to property protects or goes under the kind of the foreign legal system through the mixed courts. And of course, that manifested itself in many different ways, including, of course, the utilities companies that were sold by, So yeah, just some reflection on the continuity and the rupture question of the merchant.
Yes. No, I just add a simple question to the conversation that's been going on, which is absolutely fascinating, on the question of law and delimiting the realm of the economy and what belongs to the realm of the commercial and whatnot, the human, the non-human, the subhuman. And the question is simply whether codification plays in at any point in this story of yours. And especially putting it back in an Ottoman context, this is precisely the heyday or the beginning of, well, a global context, but an Ottoman context specifically, as of the 1840s, is when particular forms of codification, at least, are introduced, including, of course, culminating in the codification of the Sharia. But I'm wondering whether that dovetails at all with the material that you're dealing with. And going back perhaps to the first question concerning the attraction of, or the making things more predictable in that, in the the temporal schema that's required for a futures market to be realizable.
I was just going to jump in on that Ottoman connection because, and this is something where I think juxtaposition between Ottoman Empire's interests, imperial interests, and Egypt's, like Egypt emerges as like both more advanced in terms of capitalist like modernity than Ottoman Empire, because I was just thinking about the question of landed property and like milk in general. And in the codification, in that context of codification of like landed property in the Ottoman Empire, the land code of 47 was all about creating a grid of private property, so registrating property, making sure it's like an exclusive right to property, but also populating the land itself. So the process of and that is where the immigration law comes in, which is promulgated 1 year. It's actually immigration law was promulgated 1 year before land code. Okay. So like colonization or like settler law, like a settlement law. And I was just thinking that like in the Ottoman Empire, the landed interest is something like landlords emerge out of in a particular juncture of codification. So they actively like emerge out of this process of registrating land. I was just wondering if there is like a similar case of like not only codification after codification, but also registration of land on the part of landlords, or were they resisting that as well? That they were resisting that consensus of
registering the land.
registering, yeah.
Can I just add a small thing to like, because you talk quite a bit about this kind of breakdown of the monopoly. And I wonder if the temporality of that and kind of what you're potentially calling as an opening of free market to some degree has something to do, in its relationship to that temporality around codification of property laws and is when we talk. Other questions? Okay, we're gonna give you some time to respond, but you can, pick and choose.
I will.
No pressures.
This is very convenient for me because then I can evade all of the difficult questions. Sorry, but then it also creates uncertainty because I don't know where to begin. Let me start, Beha, with the first point you raised about arbitration. And I think you frame it in a more conceptual way that I'm a little bit uncertain about how to engage with, but I have a more kind of a historian's kind of concrete empirical answer that brings it, lowers the level, the intellectual level a little bit. One of the big concerns with one of the big concerns that leads to the creation of these merchant courts, which by the way are created before the first Ottoman commercial code is issued, not by long, by just a few years. And the Ottoman Code of Commerce is introduced and then kind of revised, and then there's like an addendum to it, and all of this happens within like a few years of each other in the 1850s. Like I think the last edition is 1860 or something. And as soon as each time this law is issued in Constantinople, it's basically immediately becomes a reference for the courts in Egypt. And this, I know maybe doesn't interest 90% of the people in the room, but for the Ottomanists and Egyptian historians, this is quite surprising because Egypt was oftentimes seen at this point as an exception to the Ottoman kind of legal realm. So it was quite shocking to see how Ottoman law is present, not informing, in the background and so on, but is cited as Ottoman law. According to Ottoman law, this is what we're going to do. So is the whole idea of creating this even before the introduction of codification, which I'll come back to this point, the creation of the merchant courts, basically what it does is it gives both, or not both, but kind of three parties, the government through a bureaucrat who presides over the court and kind of ensures its smooth running and serves as a tiebreaker if needed. And then the merchants, the European and Egyptian merchants who sit on the court and who are not haphazardly selected, but those themselves are quite powerful elite merchants who are able to make it there. That triangle of the senior bureaucrat, the elite Egyptian merchant, the elite European merchant, together are the ones who are going to create the mechanism for arbitration. So basically, they approve the merchant assembly that's going to oversee a resolution outside of the law. And oftentimes, merchants who preside over the court also are appointed to these assemblies. Which means that the arbitration it's happening outside of the court, yes, but it's not happening in total ignorance or kind of the law or kind of completely divorced from the regulations that run the court. My thinking is that what this is introducing is not predictability, because the way that Sharia had regulated commerce and so on was quite predictable, but rather speed. Because the government puts its weight for enforcement behind these kinds of arbitrations in particular, not the ones that happen in guilds, not the ones that happen totally informally among merchants and so on. And those sometimes, I'm sure, are happening and are being enforced by mutual agreement. But in the case especially of, as you said, foreign capital Europeans who maybe don't know their way around, or they're in and they want to be out, they're not there to stay, and so on. This mode of arbitration created for them speed and effectiveness, because they know they can recoup their money within a reasonable amount of time that will not undermine whatever else is going on, because that money is going to be reinvested maybe somewhere else. It's not necessarily going to go back into Egypt. I'm jumping around a little bit here. Codification is, there are two ways, I think, two ways of answering the codification question. One is by saying, let's trace which laws are issued when, and each time a law is issued, it means this niche, this kind of sphere of social activity is now kind of under codified law and so on. But the other way to think about it is that codification is also an ethos. So even when laws are not issued, there's no, before, say, the Ottoman commercial law is written and kind of becomes the effective law, the government, in commerce and relation to all other kinds of activity, is issuing its own administrative orders, which are written like continental legal codes. It's lists of potential transgressions of the law and kind of the punishment that kind of matches this kind of thing. And this starts, actually, back to your point, in the criminal sphere, and specifically for rural crime. This is the very first laiha, or kind of charter, that is issued and treated as law in Egypt. So codification is happening with an uneven speed and kind of in different places at different times and so on, but it's the ethos of the time. Even Sharia itself, as you said, kind of at some point there's an attempt to codify Sharia, which is a very difficult, it's a very ambitious, and I don't know if it's possible as well. Back to the issue of power dynamics. I think, by the way, May, your point about the mixed courts defining all questions of property as by definition mixed is something, thankfully, I stopped on right before the mixed court, because I didn't know that. And I was consulting mixed court cases because I'm trying to see the afterlife of what I was looking at. And especially I'm noticing now that the chapters that focus on Boutros and Hassan and Tito and so on are much difficult to have a conversation about because of the way I presented them. So unless, people read them, but I see them appearing in the mixed courts later on, and I try to trace what's happening. But I was surprised because when I saw their names appear, I assumed that because European subjecthood was not necessarily a stable thing, it's not like becoming naturalized. Right? You get that subjecthood, you might lose it, you might get another subjecthood and so on, or protege status, and so, which is less common. But when I saw it, I thought, oh, maybe they became subjects of France or Italy and so on. But apparently not. It's because the law itself redefined. Again, property here, I assume the biggest property is land, right? This is the question of property. And I guess what's happening is I think the logic of commercial law continues. And by absorbed by the mixed courts, what I meant was two things. One, that pending cases or unresolved cases went into the mixed court. And the other thing is that the resolution of commercial disputes continued to refer to basically indirectly by one step of separation French commercial law. And so on. So in that sense, on the commercial, kind of more urban side, I don't know if I'll get to the issue of speciality. Yes, that's what I'm saying. But there is continuity. There is continuity there, and the mixed courts are actually. You're right. It does signify a more stark and final kind of ascent of European political power, because it creates a big sphere, a big judicial sphere that encompasses all foreign interests or mixed interests and so on, and it figures out which kinds of laws to apply to it in there, and it kind of leaves behind that more fragmented system of the 19th century. Should I stop or should I answer one more?
I am just working.
Okay. Okay. Then we can stop then.
Okay. All right. Well, I mean, we could go on forever because it's a fascinating, it's been a great conversation that you sparked for us, Omar, today. So thank you so much, and thank you.